Good morning, everybody. I'm very honored to be invited for this 19th anniversary of your faculty and of your university. I would like to present a research project we just finished. It hasn't been published yet, and it's about motivations of court decisions of Utrecht District Court. But before I do that, I would like to make an ad. And that's an advertisement for the International Association for Court Administration. Also hearing and participating in the discussion before the break, I think that the International Association offers a useful platform to exchange experiences with court administration worldwide. And courts are very complex organizations, and within the European legal tradition, courts as organizations have always been left to the lawyers. But lawyers are not very good organizers. Not by nature. They're good analysts, but not necessarily good organizers. Judges are often excellent lawyers, but the combination of being an excellent lawyer and being a good manager is rare. So there is a need for organization in court management. What public administrationists do not understand is how immensely complex courts as organizations are. And they are immensely complex because they do so many different things. And it takes quite something to make courts work diligently and efficiently and effectively. And the relation with today's theme is, of course, very direct. Courts function locally, but they do operate in a globalizing society. So also local judges, first instance court judges, get all kinds of international problems on their plate. What I want to do today is to show you some research about Utrecht District Court, motivations for Utrecht District Court, in order to show how that court tries to be self-reflective in its functioning in the wider Dutch and European society. I do not have a lot of time, so I have to be very brief. And the research I'm going to present is very complex. The court asked me and Professor Mandy van der Velde, who is an organizational psychologist, and I cooperated with her in this project. The project took 3 years. We just finished it. The results have not yet been published. And also because of the broadcasting on the internet, I'm not going to show here the statistics. I want to preserve the statistics for a decent journal publication. The court had the idea that their decisions and their motivations were very, very differently. And you should know that first instance courts in the Netherlands, they do everything. So they do administrative law, criminal law, civil law, family law, trade law, small claims, small crimes. But they are organized in different sectors, different divisions. And judges from the different divisions, they do not know very well what is happening in the other divisions. But they have images of each other. And the board of Utrecht District Court said, well, we write such different motivations. Could you please do some research into our court to find why these differences are so big? Can you explain the differences? eventually, we ended up doing a quantitative empirical research. So we made a sample of almost 1,000 court decisions and a stratified a stratified random sample, and we interviewed 30 judges. And we were not allowed, I have to say, to interview parties or advocates for this research. So we delved deep into the way judges motivate court decisions. When searching for publications on the motivation of court decisions, you find that there are many legal and philosophical publications on how judges decide cases. And you, as lawyers or lawyers to be, and in this local, you are familiar with that way of reasoning. But there is almost no empirical research being done on court decision, on how judges write. And so we tried to find out whether the legal field would be the main factor for the characteristics of the texts the judges wrote, or that other characteristics like the case management characteristics or the conflict characteristics of the case would be more important. I had no training as an empirical researcher, so it has also been a way of discovery for me to do this research. And I experienced how cumbersome and how difficult it can be to gather good data. Lawyers, because they do not do empirical research, I find my colleagues have no clue of how much work it is. But we worked for 3 years on this research, so I'm very cautious with the results. It was trial and error, and what I show here is the result, the outcome of the trial and error. We found the following conflict characteristics as important, something to look at. Party constellation, one-shotter or repeat player, the experience of the party. Was there legal representation or was there no legal representation? What was the financial interest in the case? Was there media interest in the case? And for the case management characteristics, what was the single judge panel? Was it the 3-judge panel? Was it summary proceedings? Was the judgment issued immediately after given verbally, immediately after hearing, and written out later? Was the judgment maybe an elaboration for secondary appeal? And another management factor is the attributed standard time for the type of case. And this has to do with the financing system of Dutch courts because they are output financed. And so each type of case has a number of minutes attached to them, and the court management has to work with that. We tried to link those case characteristics to the text characteristics. And of course, what we did is contrary to what lawyers are used to and familiar with. And so, also in this audience, I feel it a little bit as a risky business. Right? We try to measure the text complexity. Text complexity, you can measure text complexity with an algorithm. It's about the number of words per sentence, the number of syllables per word, and you can make a calculation out of it. And standards have been developed a long time ago already about to scale this. And we use the scale developed for Dutch. But there's one thing you should understand. Measuring text complexity is something else, quite different from readability or comprehensibility of a text. We didn't measure the comprehensibility of the text because then you have to ask the readers, and we couldn't do that for this research. We also measured the juridical intensity, which means the number of references to jurisprudence and the number of references to legislation. That's something you can count. And we also scored the occurrence of moral considerations in the text. For example, I give you an example of what we found. We have, also in the Netherlands, we have these pedophilia cases, and a convicted pedophile was released from prison. And the guy tried to get to rent a house somewhere from social housing instances. But neighborhoods got the air of, got the scent of it, and they protested. And therefore the mayor issued a banning order. So the pedophile would not be allowed to live in Eindhoven or in many municipalities where he tried to find housing. And so he went to court. And the judge considered it, considered the case, and then annihilated the court decision and said, as an extra motivation for his decision, addressing all the majors in the Netherlands, also a convicted pedophile who has been released from prison has a right to live somewhere in the Netherlands. And so that was a moral appeal to the majors in the Netherlands. Not necessary to found the decision on, but was some extra information. He said, now the guy should be allowed to live somewhere. Okay. We connected these text characteristics to intended audiences of court decisions. Now this is a very complex issue, because what's the audience of a court decision? If you know how a judge writes a judgment, you know that probably judges themselves are a very important audience of court decisions, because of the inculcation process. They write the decision in order to better understand the outcome for themselves and for their colleagues. But of course, it's also about parties, and it is also about professional lawyers, the advocates, academic lawyers, and the general public. The media and the politicians. And you would, of course, for example, expect, I cannot repeat, and I cannot tell you all the hypotheses we formulated because it will cost too much time. But we thought that when a judge writes with a focus on parties, that the text would be relatively simple and not with a low juridical intensity. And we thought that when there would be media interest, that there would be a lot of moral considerations in the texts. What we actually found is not exactly what we expected. We found, first of all, that legal fields do make a small difference. But what we also found is that the case characteristics are much more important for the explanation of the differences in text characteristics. So we proved, if you accept the measurement of text characteristics as adequate for comparing motivation of judgments over the borders of legal fields, we found that legal field is actually not so important, and thus we found that the point of departure of the research as asked for by the board of Utrecht District Court was wrong. There are not so many differences between the ways in which judges write judgments between the different legal fields. And that was, for us, that was an astonishing outcome. And what we found is that, for example, party constellation, the experience of parties, and media interest are much more important predictors of how judges write a judgment. So for judges there is some orientation. There is some orientation on parties. There is some orientation on the wider audience. And the things lawyers, constitutional lawyers in the Netherlands are writing about is that, well, the financing system is a danger for judicial independence, because judges depend on the production for the amount of money the court gets. We couldn't find that. We found that financial interest does nothing. We did not find any statistical significance for differences in court decisions for different amounts of money. We didn't find any difference in tax characteristics connected to attributed standard time. This means that first, the judges behave independently and autonomously, as you would expect of them. And also, they don't mind about their organization. They focus on the case. So I told them, this is a compliment for how you do your work. But on the other hand, there are also some things we showed which are good for improvement. First of all, if it comes to text complexity, for text complexity, if it scores 100, it's an extremely readable text. It's a very simple text. It's a children's book text, sentences with 5 or 6 words per sentence, 2 or 3 syllables per word. But the average score of Utrecht District Court is about 45, which is beyond expert level. So there's some improvement there, and there are some differences. Especially criminal judgments score the lowest 37. And trade judgment score 52, which is expert level. So some improvements can be made, and I would also like to share an outcome which shows how difficult it may be to write for a specific audience. Of course, a judgment immediately after hearing. So this works like this. You have in relatively simple cases, single judge panel, you have a simple, the judge gives the judgment immediately after hearing. So they closed the case and said, well, I'm going to give you my sentence immediately. And this has to be elaborated afterwards. With a view to the parties. And when you look at the quality of those texts, they are flat texts. They are highly complex. They have a low juridical intensity, and they have no moral considerations. And we asked how come? And then they said, well, you know, these texts actually are being written by court secretaries, and we check them afterwards, and then we put our signature. Also, we were very focused on elaborations for secondary appeal. Also, these are criminal cases, and we could only trace them for criminal cases because of the recording system in the court, the archiving system in the court, and the audience for the secondary appeal elaborations are of course the second instance judges. And so we expected a high juridical intensity, no moral considerations, and a text of high complexity. The texts were highly complex, but there were less, the juridical intensity was much lesser than in ordinary cases. So there's something we didn't reckon with. And when we asked the judges, and they said, well, you know, we expect the appeal court judges to know the law, and so we do not have to refer to it. And which was, for me as an academic lawyer, was quite funny. Last thing, I want to communicate is that we presented the results to the judges of Utrecht District Court, and they were kind of disappointed with the research because it didn't fit their discussion. And but I told them, if I would have operated the research according to your questions, we would never have found this. And therefore, it is very good of you that you dared to ask someone from outside your court to look from outside to the inside and to use concepts you are not familiar with, and to hold the mirror towards your work. And of course, they agreed with that, because otherwise they wouldn't have asked it anyway. But it also shows how difficult it is to operate, let's say, legal concepts with quantitative empirical research. But I'm very much in favor of this, because it helps you put the work of judges into and courts into perspective. And I think that in the current time, in the current age, with globalization and immense societal complexity which are being delivered on the plate of the judiciary, that they need this type of support and help. Thank you very much.